Canadian constitutional politics are three words not normally used as clickbait in YouTube videos, and there's no exception here. Canada's Charter of Rights and Freedoms is a document that stirs up controversy and gets into the news cycle every once in a while because it's got a handy tool within it called the Notwithstanding clause that can be used to override the charter rights of citizens for the good of society at large. Why on earth would you want to override the charter rights of citizens, you ask? Wouldn't you only do such a thing when it would prevent a huge travesty? I'm sure most supporters of a just society would agree that this constitutional nuclear option would almost never be used. And if it is used, it wouldn't be used lightly. The problem comes with how different people define what a huge travesty is. This has led to the Notwithstanding clause being used more often than you'd think. In this video, we'll talk about what the Notwithstanding clause is, how it works, why it's been used in the past, and maybe why some of those past uses of the clause are a bit dodgy from a good of society perspective. There are sometimes rare circumstances where you can justify overriding the charter rights of Canadians and stop the courts from inadvertently making things worse in society through an interpretation of law. The clause allows governments to do this, notwithstanding how the courts have interpreted and applied a law. The spirit and the intention of the clause isn't just to apply it to things that are just frustrating to governments, but rather to issues that really are in the best interests of the population overall, regardless of how courts apply the law. The Notwithstanding clause is Section 33 of the Canadian Charter, and it allows Parliament or the legislature of a province to politely ignore certain other sections of the Charter. Well, why does Canada have such a thing? Well, it was one of those things that was negotiated to win the support of the provinces back in 1981 when the Charter was being drafted. Not a story for this video, but that negotiation in the kitchen of the Ottawa Conference Centre was known as the Night of the Long Knives. I'm telling you, Canadian constitutional politics is not boring stuff. Some of the provinces feared that without the clause, the balance of power between the courts and the government could be disrupted. The Notwithstanding clause is intended to be used to strengthen fundamental rights rather than weaken or disregard them. How about an example? Saskatchewan, 2018. There was an earlier court case that eliminated the use of public funding for non-Catholic students who wanted to attend Catholic schools. I'm not sure why, but the outcome of the court case was to say that Catholics were fine to attend Catholic schools and society would pay for that, but non-Catholics had to pay their own way if they wanted to go to that same Catholic school. So, in response, the Saskatchewan government passed an act called the Saskatchewan School Choice Protection Act that basically said, no, anyone who wants to go to any school receiving public funding can go there and not be made to pay for it themselves. Saskatchewan school law outlined reasons for protecting funding for non-denominational students as a way of actually bolstering the right to religious freedom mentioned in the Charter. To protect the school choice law from court challenges on constitutional grounds, the Notwithstanding clause was invoked. That basically said, we don't care what the court's reasons are for this decision, but it's the right thing to do to strengthen rights, so hands off this legislation. Great! So the Notwithstanding clause is a useful tool that is used responsibly by those in power when it's the right thing to do to strengthen rights. How about another example based on a true story? Let's say you want to pass a law that forces an employment contract on a group of poorly paid education workers that are threatening to strike. You don't want to deal with a strike. No one likes strikes. Parents are going to freak out at you if their kids aren't in school. It creates issues of childcare, and it impacts the learning process for students. You want to prevent that strike. Rather than reaching a negotiated settlement, forcing a contract is just easier. But what if this forcing of contracts has been tried before and defeated in the courts as unconstitutional? Well, you introduce a law to take away the right of these education workers to strike, you impose a contract on them that they hate, who cares, and you invoke the Notwithstanding clause to deal with the inevitable court challenge that results. Use the Notwithstanding clause, presto, there's no court challenge. Do you suppose that's what the Notwithstanding clause was intended to be used for? Does that sound like the clause strengthens people's rights? The Notwithstanding clause hasn't actually been used all that often in Canada, but every time it is used or the threat to use it is raised, it creates controversy. Alberta tried using it against same-sex marriage, and another time to limit compensation to victims of a forced sterilization program. Ontario used it in 2021 to double the restricted period for third-party spending on advertising before an election. Saskatchewan used it back in 1986 for back-to-work legislation. And Quebec, well, Quebec uses it quite a bit, actually, to shield the province's language laws from constitutional challenges, as well as to restrict the rights of people working in public service to display religious symbols. And a few months ago, Saskatchewan talked about using it to force through a law about parental rights. If you apply that question of benefit, does the use of the clause strengthen people's rights, as a reasonable test of whether it should be used, an objective person would conclude that most of the uses of the clause so far are eroding public confidence that it really is a tool of last resort to prevent significant social harms, and it's much more so a tool for governments to get what they want. An Ipsos poll in 2018 during Ontario's first use of the clause to reduce the size of Toronto's government showed that a small majority opposed the use of the clause. The interesting part of this poll was that the analysis floats the idea that the opposition wasn't necessarily about the use of the clause itself, but rather the ensuing chaos. Back in 2018, members of the opposition were being tossed out of the legislature. There were very loud protests in the streets. The authors of the study rightly stated that Canadians like order, collaboration, and cooperation, none of which were facilitated by the use of the Notwithstanding clause. There was a more recent poll by Angus Reid that showed 55% of Canadians think the Notwithstanding clause should be abolished. This poll showed that 48% worry the Notwithstanding clause weakens the rights of citizens, and 53% believes it damages national unity. How easy do you think it would be to abolish the Notwithstanding clause, or at the very least, put in place some protected parameters that guide its use for serious things rather than dumb stuff? Well, the House of Commons, the Senate, and 2/3 of the provinces representing over 50% of Canadians would need to approve changes to our Charter of Rights and Freedoms or anything else in the Constitution. And you know it wouldn't just stop with the Notwithstanding clause. If the Constitution were open to revision, every provincial leader in the country would come up with something they wanted changed. Talk about chaos. Instead, we need to show governments that as Canadians who like order, collaboration, and cooperation, if the Notwithstanding clause is going to be used, it better be for something very clear-cut, where the vast majority of reasonable people would see its use as strengthening rights rather than just pandering to the wishes of a smaller group.